Child sexual abuse is a global concern of today. More than a decade has passed since the POCSO Act was enacted in 2012. That is, Protection of Children from Sexual Offences. But we are still struggling to ensure its proper and effective implementation to impart justice to victims of child sexual abuse. India is a home to over 20% of world's children and 42% of India's total population. Approximately 50% of these children need protection, as statistics reveal that every second child has faced and endured sexual abuse before turning to 18 years, predominantly at the hands of the family members or individuals known to them. In India, a child less than 16 years is raped every 2.5 hours, while sad event occurs every 12th hour in child less than 10 years. And every 5th child faces critical forms of sexual abuse. Few do lose their life as well. According to UNICEF 2022, about 1 in 10 girls under the age 20 years have been forced to engage in sex or perform other sexual acts. In 90% of cases, the accused is known to the victim. The latest 2022 report of National Crime Records Bureau shows that out of total 1.5 lakhs cases of crime against children, in 2021 alone, that is during COVID times, 36% were under POCSO Act. That means every third crime against child relates to sexual offense. POCSO Act is a journey from no law to special law. The journey started way back in 1992, when India ratified the United Nations Convention on the Rights of the Child and pledged to safeguard its children from all types of sexual exploitation and abuse. In 2006, Honorable President of India, late Dr. APJ Abdul Kalam, in his address to the Joint Parliament session said, "The rights of women and children and their aspirations are of paramount importance in our march towards an inclusive and equitable society." In accordance, the Ministry of Women and Child Development was created in early 2006. Ministry took the initiative to undertake a nationwide study on child sexual abuse to understand the extent and the magnitude of child abuse in India. Results were shocking. The prevalence of all forms of child abuse is extremely high. Physical abuse 66%, sexual abuse 53%, and emotional abuse 50%. Boys were equally affected and harassed. Came as a shocking revelation to public and medical fraternity. Due to efforts of various NGOs and the Ministry of Women and Child Development, a lot of momentum was created regarding the absence of law around child sexual abuse, resulting in drafting and implementation of POCSO Act 2012, that is, Protection of Children Against Sexual Offences. POCSO Act comprehensively deals with the issue of sexual offences against children. It not only spells out the punishment for offences, but also sets out a system for support of victims and improved methods for catching the offenders. Juvenile Justice Act 2015 came into force on January 15, 2016 and replaced the previous Juvenile Justice Act of 2000. Under the Act, a child is defined as anyone who is below the age of 18 years. In 2019, POCSO Amendment Bill was passed with an objective of stopping the rampant sexual abuse of children. It provides more stringent punishment, including death penalty for sexual crimes against children. To decrease the pendency of filed cases, the Honorable Supreme Court of India on 25th July 2019 gave directives for creation of exclusive fast-track special POCSO courts for speedy disposal of POCSO cases for 3 years. And recently, Union Cabinet on November 29, 2023 approved the continuation of these fast-track courts for a period of 3 years, that is up to March 31st, 2026. Recently, in a story breaking the silence on child sexual abuse in the home setting, actor-politician Khushbu said that how she faced abuse from her own father and how she stood up for herself at the tender age of 15. In her story, Swati Maliwal, the president of Delhi Commission for Women, says, "My journey of overcoming horrific child abuse may motivate others to seek help." Social media trolls said that I have brought disrepute to the sacred relationship of father and daughter. It is unfortunate that even today, society tends to put the onus of protecting the family honor on the victim of sexual abuse. We are biggest hypocrites. To appear perfect and strong, how much of our lives do we attempt to conceal from those around us? Amit Shah parliamentary speech on Bharatiya Nyaya Sanhita 2023 opened a new comprehensive chapter on offences against women and child sexual offences under 18 years. It will not only give justice to victims and punish the perpetrators, but will act as deterrent. Now, statement of victims will be compulsory in a rape case. A woman can lodge an FIR in the police station through e-FIR, and the cognizance of it will be taken and arrangements have to be made to provide a reply to the woman at her home within 2 days. Life imprisonment or death penalty for a sexual violence against girls under 18 years and up to 20 years or a life imprisonment for a gang rape regardless of victim's age. While the government is making all-out efforts to ensure a safe and protected environment for our children, it is collective responsibility of all the stakeholders to enable children to live with dignity, free from violence and fear. Making of this film for health professionals, titled Understanding the POCSO Act, Examination and the Treatment of Survivor of Child Sexual Abuse, is a major initiative taken by Delhi Gynaecologists Forum and North India Gynaecologists Forum with the aim to provide knowledge of the law, procedure for dealing with sexual offences against children. Government of India enacted the POCSO Act in 2012. It is the Prevention of Children from Sexual Assault Offensive in view of alarming rise in child abuse cases. The aim was to provide strong legal framework for the prosecution of children from offences of sexual assault, sexual harassment and pornography, and to safeguard the interest of the child at every stage of judicial process. The Act defines child as any person below the age of 18 years. The Act defines different forms of sexual abuse, including penetrative and non-penetrative sexual assault, sexual harassment and pornography, and deems a sexual assault to be aggravated when the abused child is mentally ill or when the abuse is committed by a person in position of trust or authority, like a family member, police officer, teacher, and a doctor. The simple reading of POCSO Act suggests that any person, including a child, can be prosecuted for engaging in a sexual act with a child irrespective of whether the latter consented to it. The Act does not recognize consensual sexual act among the children or between a child and an adult. The POCSO Act would still apply where the offence is committed by a child. The only difference is that the procedure would be as per the Juvenile Justice Care and Protection of Children Act 2015. The Penetrative Sexual Assault Section 3. He penetrates his penis, or he inserts any object, or he manipulates any part of the body, or he applies his mouth to any extent into the vagina, mouth, urethra or anus of a child, or makes the child to do so with him or any other person. Aggravated penetrative sexual assault Section 5 means when a penetrative sexual assault is committed by a person in a position of trust or authority or public servant. Sexual assault Section 7 means whoever with sexual intent touches the vagina, penis, anus or breast of a child, or makes the child touch the same, or does any other act with sexual intent which involves physical contact without penetration, is said to commit sexual assault. Aggravated sexual assault Section 9 means sexual offences committed by a person in a position of power, authority and the trust. Sexual harassment Section 11 means when any person with a sexual intent utters a word or makes any sound or gesture or displays or exposes any part of the body with an intention that the child would hear the sound or sees the part of the body, is said to commit the offence of sexual harassment. The Act was revised in 2019. This also adds aggravated penetrative and non-penetrative sexual assault, assault resulting in the death of a child, and assault committed during the natural calamity or in any similar situation of violence. Administering any hormone or a chemical substance to the child for attaining early sexual maturity. In 2019, the bill defines child pornography as any visual depiction of sexual explicit conduct involving a child and offences for storage of pornographic material involving children. Abetment. A person abets any offence. First, instigates any person to do that offence. Secondly, engages with one or more other person or persons in any conspiracy for doing of that offence. If an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that offence. Thirdly, intentionally aids by any act or illegal omission the doing of that offence. POCSO Act provides equal security to the male and the female children. The laws are severe. The penetrative sexual assault or rape on a child below 12 years, there is a minimum punishment of 20 years or to the life and fine or death. Gang rape on a child below 12 years, there is a minimum life imprisonment and fine or death. Penetrative sexual assault or rape on a child below the age of 16 years, there is a minimum imprisonment of 20 years to life with a fine. Gang rape on a child below 16 years, there is a life imprisonment and fine. Penetrative sexual assault between 16 and 18 years, there is an imprisonment between 10 years to life and the fine. The aggravated penetrative sexual assault, there is a minimum punishment of 20 years and the maximum punishment is a death penalty. POCSO is a special law. The burden of proof is on the accused. It is a gender neutral law. Calibration of offences are there in this law. Severe punishment when protectors are perpetrators. No time limit for reporting the abuse. Maintaining confidentiality of the victim identity is must. No discrepancy jurisdiction is there. Support to the child and the family by support person. There is a mandatory reporting. Punishment for failure to report or record the case. What is the role of medical professionals? They have a dual role: mandatory reporting and examination and management. Other role: considering a differential diagnosis of behavioral complaints and signs that may mimic sexual abuse, obtaining photographic and video documentation, formulating a complete medical report, and testifying in court when required. Emergency medical care in a manner to protect the privacy of a child and in the presence of the parent or guardian or any other person in whom the child has trust and confidence. No need of any legal or magisterial requisition. Even if child or parent does not give consent for medical examination, you can still provide them with medical treatment. In case of a girl child, the medical examination is to be conducted by a female doctor. Police personnel should not be present during any part of the examination. Informed consent of parent or the guardian of the child victim is mandatory. The process of examination is shown in film. APJ Abdul Kalam said, "The safety and the security does not happen. They are the result of collective consensus and public investment. We owe our children, the most vulnerable citizen of our society, a life free of violence and fear. Childhood should be carefree, playing in the sun, not living a nightmare in the darkness of the soul."
Healthcare professionals have a dual role to play in terms of the POCSO Act 2012. They are in a position to detect that a child has been or is being abused and are also often the first point of reference in confirming that a child has indeed been the victim of sexual abuse. They have to function as advocates for child health and also to play a critical role in recognizing and management of victims of sexual abuse. The medical examination is an important tool for evaluation, identification, and detection of injuries, sexually transmitted disease, and also for collection of evidence of sexual contact. A survivor of sexual violence may report to doctor or hospital in 3 ways. 1. On his or her own, only for treatment for effects of assault. 2. With a police requisition after police complaint. And 3. With a court directive for medical examination. Parents in cases of child sexual abuse prefer to take their children to a nearest hospital or a clinic even before going to police. Under Rule 5 of POCSO Act 2012, sexual assault is a medical emergency, and emergency medical care is to be provided by medical facility, may it be private or public. No magisterial requisition or other legal document is required to provide emergency care. During care, privacy of the child should be protected and presence of the parent or guardian or any other trusted person in whom the child has trust and confidence should be ensured. Emergency medical care includes treatment of cuts, bruises, and other injuries, including genital injuries, treatment for exposure to STDs, including prophylaxis, treatment for exposure to HIV, including prophylaxis, discussion about possibility of pregnancy and use of emergency contraceptives, referral or consultation for medical or psychological health, and inpatient care if recommended. Any forensic evidence collected during the course of rendering emergency care must be in accordance with Section 27 of the Act. Doctor is bound to inform the police under POCSO Act, Section 20. According to National Commission for the Protection of Child Rights (NCPCR), providing MLC to authorities is sufficient on due part to comply with the reporting requirements of the POCSO Act. MLC must be made and victim must be informed that he or she has the right to refuse to file FIR. After giving immediate emergency care, a relevant medical/surgical history is to be taken. Detailed sexual violence history is also to be taken. General physical examination is to be done, especially the examination for injuries, local examination of genital parts and other orifices, collection of samples for hospital laboratory and clinical lab. Collection of samples for central and state forensic science lab has to be done. A detailed medical history of the child's experience is to be taken. The child is interviewed in complete privacy, in a facilitating, non-judgmental and empathetic manner. It is important to know that in case of a child, the diagnosis of sexual abuse is mostly based on history rather than physical examination. The history guides the nature and extent of physical examination and type of evidence collection. One can take help of dolls, drawings and body charts to guide child to describe where and with what they were touched. Special points to be noted like details of the culprit, familiar person or not, whether first or multiple encounters, details of physical contact, verbal threats, use of any drugs or weapons, injuries, history of penetration and ejaculation, and any change of clothes, brushing, bathing, wiping, or douching after the incident. One has to be sensitive to the child's feelings of vulnerability and embarrassment and stop the process if the child indicates discomfort or withdraws permission to continue. It is best to avoid leading and suggestive questions. Instead, maintain a "tell me more" or "and then what happened" approach. Now, it is very important that before examination, consent of the child or parent or guardian or trusted person competent to give consent on behalf of the child should be taken. Examination cannot be conducted against his or her consent. No court or person can force a medical examination. Minimum age for giving valid consent for medical examination is 12 years. In case of a child below 12 years of age, wherever parents or guardians are not available, consent can be obtained from a panel of senior doctors in administrative positions in the hospital. The right to informed consent implies the right to informed refusal also. Consent should be informed and is taken for examination, sample collection for clinical and forensic examination, treatment and police intimation. Even if the child or parent does not give consent for medical examination, one can still provide them with medical treatment. Every hospital must have a standard operating procedure for management of cases of child or adolescent or adult sexual violence. Any registered medical practitioner can conduct the examination, and it is not mandatory for a gynecologist to examine such a case. In case of a girl child, examination is to be done by a female doctor in the presence of parent or any other trusted person. If the parent or other person is not available, the head of the medical institute will nominate a woman, and the medical examination shall be conducted in the presence of that woman. Police personnel should not be present during any part of the examination. General examination, including mental status, sign of intoxication, vitals, and extent of injury, has to be done. Details of clothing should be noted. Record the height and weight of the child, as the neglect may coexist with sexual abuse. Record the child's sexual development stage, that is standard staging. The entire body surface should be inspected carefully for signs of bruises, physical torture injuries, boils, lesions, especially on the scalp, face, neck, shoulder, breast, wrist, forearms, medial aspect of the upper arm, thighs, and buttocks. Description regarding type of injury, site, size, shape, color, signs of healing should be documented by marking on the body charts. Any grievous injury, if present, should be mentioned separately. Note the type of stain, blood, semen, lubricant, etc. With careful planning and attention to detail, physicians can win the confidence so that the genital examination is a non-threatening, non-traumatic experience for the child. The child should be allowed to dress and undress in privacy, wearing a gown for the examination. Girl child can sit on the parent's lap in the supine frog-legged position. This allows for adequate visualization of the introitus and anus. In boys, the lateral decubitus position allows for an adequate examination. The child should be undressed as necessary and be allowed to dress as soon as the physical examination is complete. More extensive examination in child and adolescent should only be done when warranted. The examination and treatment may have to be performed under general anesthesia in case of minors and when injuries inflicted are severe. Local examination of genital parts and other orifices is done carefully. External genital area and perineum is observed for evidence of injury, seminal stains, and stray pubic hairs. In case of a female child, the vulva is inspected systematically for any signs of recent injury such as bleeding, tears, bruises, abrasion, swelling, or discharge and infection. Very important point is retraction of vulva in proper direction, that it is downward and towards the examiner and not spreading in the width, as it may cause tear in posterior foresheet of a small child. A note should be made of any vaginal discharge, its texture, color, odor. Per vaginal examination should be conducted only if indicated and should not be conducted routinely. It is very important to note that one should not conduct two-finger test on victim of sexual assault. Per rectal examination done to detect any tear, stain, fissures, hemorrhoids in the anal canal based on history, and relevant swab from these sites should be collected. Oral cavity should also be examined. Now, a forensic examination is done to ascertain whether a sexual act has been attempted or completed, whether any injury has been caused to the child's body. Absence of injuries does not imply that no assault occurred or that the child had consented, whether such a sexual act is recent, the age of the child in the case of adolescent girls and boys, whether alcohol or drugs have been administered to the child. As far as age estimation is concerned, it is not necessary to do medical age estimation of the survivor in all cases. Age estimate should be done only when in doubt, when reliable documentary proof of age is not available, and if requested by police. A combination of physical, radiological, and dental age has to be determined to reach a conclusion. It is mandatory to take X-rays of wrist, elbow, and shoulders for radiological age estimation. We have to collect and preserve evidence using the SAFE kit within 96 hours, that is 4 days of the assault. Preserve the clothes and other relevant material. The spermatozoa can be identified only for 72 hours. Collect samples for DNA profiling, forensic evidence from hair, nails, body surface or orifices, any product of conception, before washing, cleaning, or the child urinates or defecates. Collect blood samples for intoxicants and blood group. Evidence on the outside of the body surface and on materials such as clothing should be collected even after 4 days. If the child resists examination, address child's wear. Provide utmost comfort and care, like examining very small children while on their mother's or caregiver's lap. If the child still refuses, the examination may need to be deferred or even abandoned. Never force the examination, especially if there are no reported symptoms of injuries, because findings will be minimal and this caution may represent yet another assault to the child. Sexual abuse of children is usually not physically violent. In the large majority of children, the physical examination is normal. This is a very important point to remember. A normal or non-specific examination does not rule out sexual abuse. After the examination is complete, the child is permitted to wash up using the toiletries and use the clothing provided by the hospital if her own clothing is taken as evidence. Admission should not be insisted unless required. All services are completely free of cost. A copy of all documentation must be provided to the survivor free of cost. The evidence collection kit should be sealed with tamper-proof seal. The responsibility of this lies with the examining doctor. All blood samples must be refrigerated until handed over to the next in chain of custody. The hospital must designate certain staff responsible for handling evidence, and no one other than these persons must have access to the samples. This is done to prevent mishandling and tampering. If a foolproof chain of custody is not maintained, the evidence can be rendered inadmissible in the court of law. A log of handing over of evidence from one custodian to the other must be maintained. If clinical signs suggestive of STD, start PEP, that is post-exposure prophylaxis. Serum samples should be obtained for baseline testing for hepatitis B, syphilis, and HIV. According to immunization status of hepatitis B infection, if victim is non-immunized, status unknown is there, give hepatitis B vaccine. Tetanus toxoid vaccine should be given if earlier not immunized. HPV vaccine is recommended for sexual assault victims. Do a pregnancy test. When a pregnancy test is positive from an assault, option for MTP should be given. The products of conception should be sent as evidence to forensic science laboratory for establishing paternity as well as identifying the accused. We need to give psychological care to all the victims. The health professional must provide this support himself or herself, or ensure that there is someone trained at the facility to provide the support. Emphasis should be given to the importance of follow-up. It is ideal to call for re-examination after 2 days so that development of bruises and other injuries may be noted, and thereafter at 3 and 6 weeks. All follow-ups should be documented. Test for pregnancy on follow-up visit should be done. Assess the psychological sequel and reiterate need for psychological support. So in summary, we have to give emergency medical care, medical history, making the medico-legal certificate and informing the authorities, consent, general physical examination, examination for injuries, local examination of genital parts and other orifices, collection of samples for hospital lab, clinical lab, central or state forensic science lab, collection, packaging and forwarding of evidence, treatment, referral and follow-up care.
My colleagues Dr. Sangeeta Gupta, Dr. Gaurav Agarwal, Dr. Kiran Agarwal, Dr. Rashmi Jain and Malti have presented to you state-of-art film on POCSO Act. Child sexual abuse is the biggest torture affecting the physical and mental health of the child, the marks of which stay with the individual throughout their life as bad memories. POCSO Act is a general neutral act recognizing that both girls and boys are victims of sexual abuse. Children are the future of this country, and all threats faced by them have to be combated on all fronts and at all levels. Government is serious about zero tolerance policy as far as child sexual abuse is concerned, and wishes that conviction rate should be increased at all cost. There is an urgent need that inclusive approach is followed as is shown in this particular film in letter and spirit to protect every child from sexual abuse and exploitation irrespective of gender. Punishment in POCSO Act are stringent and harsh than any other legislation in this country. Fast courts are already established. It is expected that medical fraternity does mandatory reporting, empowers themselves in the state-of-art medical examination, formulating complete and thorough medical report, diagnosing and recommending treatment, and testifying in courts if required. So no perpetrators of crime should go scot-free just because of lack of evidence. Thank you very much.